Well, welcome to the panel on navigating abuse of dominance, a topic that remains at the core of competition law enforcement and that keeps changing as we gain experience and as we evolve in terms of legal interpretation, but also as markets themselves evolve and we have to adjust. This discussion takes place at a very important moment because the European draft 102 guidelines for exclusionary abuses have renewed the debate around how we assess exclusionary conduct and what are the limits for the behavior of dominant firms. And the process, although of course not necessarily the debate, is almost coming to a close. At the Lisbon Conference 2 years ago, there was an amazing panel in anticipation of the draft guidelines by the Commission. The truth is that the guidelines were since then published. There was a public consultation to the draft guidelines. There was a stakeholder event. And according to the website of the Commission, they're expected to be published, the final version, until the end of this year. But maybe Max will tell us more about that. It comes at no surprise that the draft guidelines were received with mixed reviews. Some quadrants argue it marks a rollback from a more economic approach to the exclusionary abuses, be it for the alleged lack of safe harbors, or because of the introduction of rebuttable presumptions for certain categories of conduct, be it on the claimed overly broad and open-ended legal framework that gives some space in terms of enforcement discretion, which some worry could shield legitimate competitive behavior. Then on the other side, so you always have, that's what you expect to have very different views. Others argue that the draft guidelines overly focus in codifying the law rather than innovating drastically, that they are oblivious to exploitative abuses and that they should have a stronger focus on consumer harm and compensation. Such diversity of perspective is expected, and I think that a very positive word must be given to the Commission for the openness of the process, the whole process. I think that's really inspirational. Now, the fact is that we have been debating exclusionary abuses and the draft guidelines, but enforcement keeps on. So we had a lot of decisions since the draft guidelines process started. And we have new trends emerging, right? I remember that a while ago, the enforcement of the Commission in terms of 102 was completely focused in terms of exclusionary abuses. And you had a few exploitative abuses at the national authorities level, but things are changing and now you're starting to see cases that have exploitative angles or at least are hybrid angles. And I think that it shows that, you're always trying to keep up, but the train just goes a little bit fast ahead of us, and it's difficult to keep up with the developments. Okay, so what we are going to do in this session, we are going to unpack all the key themes and the strategic choices reflected in the draft guidelines. We are going to try to discuss how they align or they diverge from existing case law, from economic theory, and from enforcement practice. We are going to discuss the use of presumptions, the notion of competition on the merits, the role of the consumer welfare standard that we were just discussing before with Sir John Vickers, the principle that some call the as efficient principle. So we are going to keep into the core of the guidelines, and we have a great panel to do that. So a warm welcome to Chiara Fumagalli, a full professor of economics at University of Bocconi and dean of the undergraduate school. As you know, Chiara has extensively studied exclusionary conduct, and that will provide the economics angle into our discussion. So we're really glad to have you here, Chiara. We are equally delighted to welcome Ioannis Lianos, a professor of global competition law and policy and the founding director of the Center for Law, Economics and Society at the UCL Faculty of Laws. I believe that the last time that you were in a panel, you were still the president of the Hellenic Competition Commission, and now you come here as an academic, but one that has published also extensively, including regarding 102. Another warm welcome to Maximiliano Cadar, who is head of unit at DigiComp. He leads the work of the ICN on private enforcement of Articles 101 and 102. He has played a central role in shaping the draft 102 guidelines. We heard him 2 years ago. He couldn't say a lot then, but there's a draft out for us to comment, so we're looking forward to hear what Max has to say this time around. And last but not least, it's a pleasure to welcome Pinar Akman, professor of law specializing in competition law at the University of Leeds. Pinar has just recently joined White & Case, but before that she served as a judge at the UK's CAT and as a member of the Financial Conduct Authority's Innovation Advisory Group. Both Pinar and Chiara have made joint papers regarding 102, and Chiara bringing together with Massimo Motta the economics to the discussion, to the article, and Pinar being the legal angle. So it's a perfect panel for our discussion ahead. But before going to that, I'm going to ask Max to kickstart the discussion by walking us through the draft guidelines and the feedback that you received in public consultation. We're really looking forward to listen about that. Max has some slides. Okay, they're up.
Fantastic. So good evening, Anna Sofia, and thanks a lot to you and to Nuno for the kind invitation. It's really a pleasure for me to be here in Lisbon for the second time, indeed. 2 years ago it was fantastic, and again, congratulations for having managed to put together such a great program. So it's really a pleasure to be here. So I will start with a couple of disclaimers, as usual. So first of all, I'm here in my personal capacity, so my views are personal. They may or may not represent those of the European Commission and DigiComp. And then another important point, and Anna Sofia, you mentioned that indeed I'm the project manager for the guidelines initiative, but at the same time, I do not want to give the impression that the views that I have today are necessarily those of the draft guidelines, because in the meantime we heard a lot of views on the text. There were judgments from the EU courts, and so it's not necessarily the case that my views are crystallized at the time of the draft, and I will say a few words today, which I hope will shed some light on this. But again, they are my personal reflections and considerations, so take them please as such. I will start with a few words on what we have done so far. Indeed, the idea is really to kick off the debate in the hope that it can be helpful also for my other co-panelists. So as everyone in the room should know by now, in the area of Article 102, there are currently no guidelines on Article 102. No Commission guidelines, unlike other instruments, of course, merger control of Article 101, for example. What we have is the famous guidance paper issued in 2008, which was really helpful in promoting a shift towards what people call an effects-based approach. And since then, of course, there have been a number of judgments by the courts which have really endorsed the effects-based approach, and that's great news because, again, the Commission was in the front line to try and promote the adoption of the effects-based approach, and, of course, the Commission has also gained significant enforcement experience in the area of exclusionary conduct in particular. So the question now is not anymore whether we need or not an effects-based approach, but it's really how to implement an effects-based approach that takes into account modern market realities. Sir Vickers was speaking before about dynamic effects. That's a very relevant element in today's world, and an effects-based approach that enables an effective, and I would add, timely enforcement of Article 102. And so the purpose of the Guidelines Initiative is really to try and provide an answer to these questions. Anna Sofia has already mentioned the timeline. We had the initiative kicked off in March 2 years ago. Then we published the drafts last year. We had a number of important judgments between September and October, in particular on Google Shopping in Intel 2 by the Court of Justice and Google AdSense and Qualcomm by the Geneva Court. I should say that the timing of the consultation was such as allowing stakeholders to take into account these judgments when submitting their comments, and to that effect, we also granted some extension of deadlines in submitting the comments. Then in February this year, we had a stakeholder workshop that I would consider very successful. We had more than 120 participants in person and quite a few remotely. And we had a very frank and open, I would say, exchange of views. And personally, I would say that this was indeed a very important element of success of the initiative, because we had a very good debate. And that was certainly very interesting. And then, still in February, we had the judgment by the Court of Justice in the Android Auto case, which is another very important ruling. In terms of outcome of the public consultation, just a word on what we have received, and I will try to simplify to some extent, being aware of the fact that this may result in some statements that are general because of that. We had more than 110 written submissions, which is quite a lot. More than 120 stakeholders, as I said, participated in the workshop, and by and large, the vast majority of the respondents did welcome the initiative, in the sense that they acknowledge that guidelines in the area of exclusionary abuses have the potential of clarifying the law and promote legal certainty, but at the same time, when it comes to the specific substantive topics, it's clear that there is no consensus in many areas. Some of those have been mentioned earlier. We'll see a few words more on the specifics, but again, if I have to simplify and be very generic, I can say that academics, public authorities, and business associations were generally supportive, with some exceptions, of course, whereas on the other side, large businesses, law firms, and economic consultancies were generally critical. And in all of this, the ECN and CAs have published a joint statement which supported the text of the draft guidelines on the 2nd of September last year. What are the areas on which we're reflecting at the moment, notably in light of the outcome of the public consultation, but also in light of the judgments? We will go more into details on pretty much all of this, so I will be very, very short. First of all, there were several calls for more safe harbors. Here, the call was legal certainty, in particular on dominance. It was a famous footnote referring to the exceptional possibility of identifying dominance with a market share below 10%. That was heavily criticized, but more general, there were calls for restoring the safe harbor 40% market share threshold that was included in the guidance paper, below which dominance can be found, but only exceptionally. When it comes to pricing conduct, here the main area of criticism was that there was too much leeway and freedom for the Commission to find an abuse in pricing situation above cost, and so we are certainly reflecting on both of these criticisms at the moment. There were calls for providing more clarities on the notion of competition on the merits and exclusionary effects. On the use of presumptions, I think it's fair to say that there was a general acknowledgement that presumptions as such can play an important role in streamlining enforcement, but at the same time, the real debate here was on the specifics. So which type of conduct should be subject to a presumption, how do presumptions work, and so on and so forth. And we're going to go much more into details on this. One interesting point is that the jurisprudence in the meantime has mentioned with increased frequency the notion of infringements by their very nature. You will remember that in the draft guidelines we had this notion of naked restrictions. The court seemed rather to favor the terminology that you can find in Article 101, so by object infringement Article 102, and so we're, of course, trying to reflect and think about what to make of this concept. And then on the well-known concept of the equally efficient competitor. Some stakeholders refer to it as a principle. I personally do not like this terminology because I think that principle is something that is universally applicable, whereas the relevance of the concept of an equally efficient competitor, the court has told us that it can be relevant in some situations, but not in others. But in any event, it is quite clear that this concept has become increasingly prominent in the case law, also after the publication of the draft, and so we are reflecting on how to make sure that this prominence is also in the final text of the guidelines, and related to that, of course, there's also the application of the price-cost test, on which we received several requests for clarifications on the use of the price-cost test in itself. And last but not least, I do not think we will go necessarily in the details on this, but there were several calls for providing more explanations on the framework to assess objective justifications. So both the objective necessity defense and efficiencies. And this is also an area which we are reflecting at the moment. I'm not going to say anything on the next steps because I will leave this for later. So thank you very much, and I'm very much looking forward to the debate.
Thank you, Max. That was very rich and insightful. Just before I move on to Pinar, you mentioned that you don't believe in the as efficient competitor principle, and we are going to be discussing that later on. Ioannis, and who was nodding to what you were saying, and Chiara later on will debate this. But when you say that you don't like it as a principle, because just because then you know you're going to comment, but maybe not state upfront your thoughts. When you say that a principle is something that should be applied to every situation, and thus you do not agree with the idea of a as efficient competitor principle, when does it not apply in your view? What are the situations that we are trying to account in this resistance to the expression as competitor principle?
Look, it's fairly similar. Let's start from, let's take one step back. I think that the main problem I have with the notion of an as efficient competitor principle is the fact that different people refer to different things when they talk about the as efficient competitor principle. So if we are talking about the statement which is coming again and again in the case law about the fact that Article 102 is not aiming at protecting inefficient competitors and does not prevent the exit of inefficient competitors, I think we can all agree that this is a general statement that finds application across the border, and I have no problem with that. But the problem is that some commentators and stakeholders have a completely different interpretation of this notion of as efficient competitor, and they submit that in order to prove a case, we need to show that the conduct would be capable of excluding an as efficient competitor. And here I think we start with the problems, because that's not exactly what the court said. In Google Shopping, again, the court says that, yes, it is relevant when a company submits that a conduct will not be capable to exclude competition, with a reference to Intel, by the way, very specific case. And in that case, the Commission has to look at the possible strategy to exclude an as efficient competitor. But again, it's a specific scenario. And then when you look at concrete applications, we know that in pricing conduct, this concept is very helpful, in some cases even a necessary element of the infringement, from my personal point of view. But when it comes to non-pricing conduct, it's a concept that is very, very difficult to be operationalized. And so I would be personally very reluctant to say that this is a legal standard when it comes to non-pricing behavior. And so I prefer to talk about the concept of a sufficient competitor rather than referring to it as a principle in order to avoid misunderstandings.
It's great, and it sets the basis for discussion that, later on that we're going to have. But now let me move on to Pinar. Pinar, I would like to have first, if you could share with the audience your general take on the guidelines, if it was, you know, in terms of what their stated objectives were. What do you think of the strategic choices that were made? Do you think that they are able to provide guidance, or do you think that they're, you know, if you agree with the criticisms that some state that they're simply codifying the case practice and not you know, innovating a lot or giving a lot of guidance? I need to touch upon many points. So Sir John was saying I made a long question. Well, imagine this one. It's really long. This is really, really long. Because I would like you afterwards to zoom on two important aspects. They're, I think, the two most prominent innovations in the guidelines. One is the emphasis on competition on the merits, and the other one is the introduction of rebuttable presumptions. Pinar.
Thank you, Ana Sofia, and thank you very much to the Portuguese Competition Authority for this kind invitation. I'm honored to be here. Just a word on disclosure before I start. As you mentioned, I joined White Case a few days ago, so I should note that I don't actually have, I'm not involved in any matters there, because I only started about 96 hours ago, I think, and I don't have any client engagements, but obviously White Case has clients on both sides of this debate. I should also clarify that I'm still a member of the CAT in a runoff period. And related to that, nothing I say today should be taken to reflect the position of the CAT or White case for that matter. So I'll start by explaining what the guidelines state their objectives to be. So the guidelines aim to codify the case law, enhance legal certainty, and help undertakings to self-assess and guide national competition authorities and national courts in Europe when it comes to applying Article 102. In terms of strategic sort of choices made, I think it's useful to say the guidelines reflect the perception, and these are not my thoughts, this is what the policy brief that came before the draft guidelines explained. They reflect the perception that the move towards an effects-based approach involved a heightened substantive legal standard accorded to Article 102, which may inadvertently lead to undesirable outcomes, such as false negatives, by setting the bar for intervention too high. Thus, with the guidelines, the European Commission aims to adopt a so-called workable and effects-based approach. Now, the objectives of the guidelines in relation to codifying the case law and providing guidance and enhancing legal certainty, and I think the latter of those two are really valuable and important objectives. I have some objections to the objective of codifying the case law, but I'm not going to go into that today. We explain a little bit why that's a bit problematic in the paper with Chiara and Massimo Motta. But all of these objectives must be viewed against the background of the case law of the Court of Justice of the European Union. And that's because neither the codification objective nor the guidance or legal certainty objectives can be achieved if the guidelines depart from the case law in major ways, and especially if they do so without offering a robust alternative framework which the courts in future may choose to adopt as an alternative approach. And before discussing in detail the sort of specific features of the guidelines, which will hopefully answer some of your questions, I'd like to talk a little bit about the case law. And I think the first thing to mention in relation to the case law is that the case law of the Court of Justice has significantly evolved in the last 15 years or so, starting with judgments such as Deutsche Telekom and Post-Denmark, towards a more economic or more effects-based approach. Notably, as Max has also mentioned, the Court of Justice has repeatedly endorsed the principle that competition on the merits may, by definition, lead to the exclusion of competitors which are less efficient and so less attractive to consumers in terms of price, choice, quality, innovation, and so on, than the dominant undertaking, and that Article 102 prohibits practices which have an exclusionary effect on competitors as efficient as the dominant undertaking. And I think the first Intel judgment epitomizes the evolution of the case law towards a more effects-based approach. In Intel, the Court of Justice, I quote, clarified some of its most formalistic case law, that on exclusivity rebates, and said that to be abusive, conduct must be capable of restricting competition and of producing the alleged foreclosure effects. But I think it's really in cases after Intel that we can actually see the true impact and significance of Intel itself and the clarification of the Court of Justice. So post-Intel cases such as generics, SEN, Unilever clarified that the principles in Intel are not just relevant to pricing abuses, and that the effects-based approach, which analyzes the conduct's capability to foreclose, applies to all exclusionary abuses. So Unilever held that at the stage of classifying an infringement, the competition authority must ensure that the relevant practice was actually capable of excluding competitors as efficient as the dominant undertaking, where the dominant undertaking disputes this or argues that its conduct is justified, and which dominant undertaking would not. Thus, Intel is not limited to cases where the Commission has applied the as efficient competitor test, which was one interpretation of Intel when it first came out. So I think if we look at sort of the entirety of the jurisprudence in the last 15 years or so, I think the preponderance of that jurisprudence, or the jurisprudence predominantly tells us, and I'll come back to why I'm qualifying my statement in that way, the evolved jurisprudence tells us that to establish abuse, one needs to engage in an analysis of the foreclosure effects of the practice on hypothetical as efficient competitors. Again, I quote, having regard to all the relevant facts surrounding the contested conduct. In my opinion, based on my reading of the jurisprudence, in terms of where it has got to in the last 10, 15 years, there are no presumptively abusive practices. Or in other words, conduct cannot be found to be abusive anymore based on its form alone. And again, based on my reading of the case law, this efficient competitor principle, and not the test, is a guiding principle of this more effects-based approach. Now, the reason I qualified my statement about the case law by saying the preponderance of the case law suggests this is because the case law is, in my opinion, at the moment, in a state or in an era which I have called the hybrid era in a recent article I published in the Oxford Journal of Legal Studies, which studies and tracks the evolution of the case law. I think it's in a hybrid era because what we see in these recent cases is that the court repeatedly mixes some of these, what I would call the legacy traditional concepts, such as competition on the merits, with a more modern economics-oriented approach. So in SEN, for example, which by all means follows an effects-based approach, the Court of Justice defines competition on the merits, a term it repeats 15 times in 16 pages, in terms of the no economic sense test, and tells us that the ultimate objective warranting the prohibition of an abuse of a dominant position is the, I quote, well-being of intermediary and final consumers, which I think in economic terms would mean a broadly defined consumer welfare standard. However, the court also finds that the competition authority can discharge its burden of proof by showing that conduct can impair an effective competition structure. Again, a legacy concept, in my opinion, that we can see in cases as far as Hoffman-La Roche, by using resources or means other than those governing normal competition. Again, a very traditional legal concept which doesn't sit easily with an effects-based approach. But then again, according to the court, the dominant firm can save its practice by showing efficiencies for consumers. And to me, what this says is that the court is clearly trying to manage essentially what is a tug of war between a more economic and a less economic approach. Now, turning to the guidelines, against that background of the case law, the draft guidelines, to me, demonstrate a selective reading of the case law, especially of the case law after Intel. First of all, the guidelines elevate the abstract notion of competition on the merits to a standalone component of the legal test of abuse. Now, in Unilever, the court had used some perhaps confusing or unusual conceptualization of this in comparison to previous case law. So the court had said that an abuse can be established based on either effects on its efficient competitors or the use of means other than those which come within the scope of normal competition, that is to say, competition on the merits. And perhaps this is where the inspiration for the test in the draft guidelines came from. But later in European Super League, the Court of Justice essentially removed the word or from that statement and held that to establish abuse, it's necessary to demonstrate that through using a method other than competition on the merits, the conduct has the potential to exclude as efficient competitors. So it seems that European Super League is suggesting that competition of the merits and the potential to exclude as efficient competitors are not necessarily two distinct criteria or two distinct elements of an abuse, but essentially two sides of the same coin when describing abusive conduct. In contrast, we see in the draft guidelines that there is a framework whereby any abuse requires two distinct elements. First, competition of the merits, and then second, the capability to produce exclusionary effects. And in that order, which is the opposite order in which these were expressed in European Super League, for example. So regarding competition on the merits, the guidelines do not really offer us any operational principles which could elevate this sort of abstract notion into a stand-alone element of a legal test. Indeed, some of the relevant factors to identify competition on the merits or off the merits actually overlap with the relevant factors for assessing the second prong of abuse, which is the capability to produce exclusionary effects. And the guidelines have chosen, or draft guidelines have chosen, not to adopt the definition of competition on the merits that was offered by the Court of Justice in SEN, which, as I said, relied on essentially the no economic sense test. Instead, that sort of conceptualization of the court has been translated into the concept of naked restrictions in the draft guidelines, which has been presented as a separate category of conduct on its own, although again, in my opinion, its use in the case law is actually highly limited. Then turning to your question on presumptions, which is perhaps the second most important sort of novelty of the guidelines. So the guidelines introduce presumptions for both prongs of the test, both for competition on the merits and also the second prong. And I think, especially regarding the second prong, so the proof of capability to produce exclusionary effects, we see sort of a particularly innovative approach to the case law and to how to establish abuse. So the guidelines heavily utilize presumptions for proving capability to produce exclusionary effects for many practices, in fact, for almost all practices that have ever found to be an abuse by the Court of Justice, except for a few like self-preferencing and so on. But in particular, exclusivity rebates, predation, certain unidentified forms of tying, and so on, are all subject to a presumption that these sort of inherently have the capability to produce exclusionary effects. And according to the draft guidelines, the case law has, and this is a quote, has developed tools which can be broadly described and conceptualized for the purposes of these guidelines as presumptions. But unfortunately, there aren't any references to case law on this point. And again, as far as I'm aware, the case law contains no true presumptions in the legal sense of a presumption, except for the case of predatory pricing, where prices is below average variable cost. So it's unclear where these presumptions have come from in terms of the case law and why, for example, some of these practices are subject to these presumptions, but not other practices. And I think perhaps what's happened is that the guidelines have used the unfortunately cryptic way in which the Court of Justice in Intel expressed the relevance of the as efficient competitor principle and the relevance of the analysis of the effects of conduct to create a test for abuse which shifts, according to the Commission, the evidentiary burden to essentially disprove a presumed capability to produce exclusionary effects. And interestingly, these presumptions now apply to many practices for which the Court of Justice's recent case law has actually articulated the applicability of the as efficient competitor principle and an effects-based approach. And in practice, depending on the standard of proof, so what is required in terms of being able to rebut these presumptions, the presumptions could de facto shift the burden to the dominant undertaking to essentially disprove that its otherwise presumptively abusive conduct is not abusive. But in any case, I think the way the presumptions are operationalized in the draft guidelines, we can see a move back to a more form-based approach and somewhat away from an effects-based approach. Finally, in terms of discussing the general rule where the Commission would have to actually demonstrate capability to produce exclusionary effects, so where the presumptions do not apply, I think the draft guidelines, to a large extent, ignore the parts of Court of Justice holdings which directly refer to these effects being effects on as efficient competitors. And unfortunately, in their current state, the draft guidelines do not really explain on whom or on what these effects need to be demonstrated, but they do make reference to competitors in more general terms rather than as competitors which are, at least as efficient as dominant undertaking. And the guidelines actually explicitly note that the assessment of capability to have exclusionary effects does not require a showing that the actual or potential competitors that are affected by the conduct are as efficient as the dominant undertaking. So I think, in essence, the guidelines somehow read the as efficient competitor principle out of the case law through, again, a somewhat selective reading of the case law. And I think in that sense, going back to your very first question, their ability and value in terms of providing guidance becomes questionable, because the question is, well, if these guidelines say one thing, but the case law says another thing, what do the national authorities do? What do companies do in terms of arranging their conduct on the market, and so on? So I'll leave it there.
Thank you so much, Pinar. That was very thorough. And I think we can look, for example, at presumptions. They can be codifying the law, but they might also be codifying the economics that we have learned, and that can set the basis for assuming some things. So with that, I will turn to Chiara to ask you, given everything that you have written and taught throughout the years on exclusionary practices, how do you look at these draft guidelines? And in particular regarding presumptions, what is your view, not only on how they are in the form that they have taken in the guidelines, but also in theory, which form you think they should have taken? And if you think there's any way that we can reconcile the concept of competition in the merits with economic theory, how can we read them?
Okay. Yes, and thank you to the organizers for involving me in this great conference. It's a great pleasure to be here. Okay, on the presumptions, I have a different view from Pinar, and we have expressed these different views on the paper that we have written together, because in general, I tend to support the idea of establishing presumptions for practices whose anti-competitive potential is particularly strong, because I believe that they may make enforcement more effective, speeding a bit the process, speeding up the process, and also they can rebalance a bit the position between the dominant companies and the antitrust authorities, the latter suffering from limited information and resources. I think this, based on the research I've done, which has explored especially exclusive dealings and exclusivity rebates, I think that presumptions for these practices make a lot of sense, because now there is a large body of the literature that gives underpinning to the fact that exclusive dealing and exclusivity rebates have strong anti-competitive potential. And especially the literature, what is important for me is that the literature has clarified the mechanism through which these practices can lead to exclusion, and exclusion that is detrimental for consumers or total welfare, and also the conditions under which this mechanism operate. And the second important finding of the literature is also that when exclusive dealing and exclusivity rebates are involved, not only losses are not necessary to exclude, but not even profit sacrifice, which implies that the price-cost test is not an appropriate tool for these practices to distinguish when they are abusive and when they are not. So also the fact that the guidelines clarify that a price-cost test may not be necessary in cases involving exclusive dealing and exclusivity rebates, I think it's a very important step forward. Said that, I have a couple of buts. First, that yes, presumptions need to be really rebuttable to make sense and therefore the guidelines should clarify a little bit what is the standard of proof for these presumptions, at least to eliminate the suspicion that they want to be a way to go back to a form-based approach and per se prohibitions. The second but is that, for instance, the guidelines suggest presumptions also for tying, and they are not very clear in two respects. First, because they say for some categories of tying there will be a presumption, for others there will not be, but it's not clear which tying belongs to the former and to the latter. And secondly, because, but maybe we can go back later to this, I don't know.
The tying.
Yeah.
Yeah, please go ahead, Kat. I think it's,
No, for the tying, I think it's true that the economic literature now has also developed a large body of knowledge establishing that tying can be, again, a way, a practice through which a dominant firm can, in a profitable way, exclude to the detriment of consumers. There are various mechanisms through which this may occur: imperfect rent extraction, exploitation of scale economies in the tight markets, or commitment to an aggressive pricing on R&D. But so, on the one hand, this has been clearly established, but on the other hand, we know, and we see it continuously, that tying is a way through which, especially in digital markets, significant innovation is introduced to the benefit of consumers. So I'm not so sure. While for exclusive dealing and exclusivity rebates, I think economic thinking supports rebuttable presumption. I'm not sure I would say the same for tying, for instance. The other big question is about reconciling competition on the merits and economic thinking. I'm not able to do that. I must, in this respect, I'm very critical with the guidelines, because we have tried hard to do that, but for me it's not possible to reconcile. So I don't understand from the economic perspective what competition on the merits means. We started thinking, okay, competition off the merits could be the use of a practice that doesn't make business sense if one takes the existence of the competitor as given. So in situations in which so the primary objective is to exclude, and only when it leads to exclusion that practice makes sense, is profitable. But we know, even if we stick to the exclusive dealing and exclusivity rebates examples, we know that these practices can be used in situations to exclude, and to exclude to the detriment of consumers, but in situations in which the primary goal is to extract rents from rivals or to exploit the demand-boosting effect, and even though exclusion is a side effect, and is a side effect that generates harm to consumers. So in this case, the idea of competition of the merits when it is not profitable unless it excludes, or the primary goal is to exclude, doesn't apply. Then one could think of associating competition of the merits to the existence of profit sacrifice. But again, this doesn't work, because with exclusive dealing and exclusivity rebates, we know that they may lead to exclusion without entailing any profit sacrifice. So that doesn't work. Then we can associate competition of the merits to the fact that there is no level playing field. There are asymmetries between the dominant firm and the rival. But again, I don't think it makes sense to say, okay, we consider abusive any practice adopted by a dominant firm when there is an asymmetry relative to rivals that can have many different sources. And also, another possibility is, okay, competition of the merits exists when a dominant firm adopts practices that automatically exclude, like exclusive dealing, sometimes tying, refusal to supply, even exclusivity rebates. But we know that all these practices can also have important and strong efficiency justification. So, bottom line, I cannot find a way to justify or to define economically the notion of competition of the merits. And I don't understand why not using a much, going back to what John was saying before, a clearer notion of consumer welfare standard, which is clearer, while competition of the merits or not the merits is being difficult to define, doesn't serve the goal of the guidelines to provide legal certainty. Consumer surplus is easier to understand, is flexible enough to incorporate price, but not price effects, dynamic effects, uncertainty. So why not being clearer on this respect?
Thank you, Karen. I must say that I'm always puzzled by, the need, after so many years, for us to say that consumers' welfare is not only about prices. I think it has never been only about prices, and I thought that was clear. The debate always surprises me a bit, and I think that your elaboration with Massimo in trying to honestly find a way to reconcile, it's very interesting in your paper. I also would like just to make a comment. Sometimes it's all about the words and the jargon, right? And also presumptions, because what is a presumption? At some point, with enough elements of evidence, you presume harm. The issue is when you do it, right? How much evidence, how much economic theory has established to allow you to make that conclusion. Now, let's move on to Yanis, who is going to have a different take on all of this. I think, Ioannis, first, you live less badly with ambiguity in terms of the wording than we. So what I would like is to know, what do you think about the draft guidelines? You were here 2 years ago. Did they met somehow your expectations? What do you think about the approach taken on the naked restrictions, which you call the dark side? And you mentioned this, that 2 years ago, the dark side, here in this room, and also about the presumptions. What are your thoughts?
Thank you very much, Anna Sofia and Nuno, for the kind invitation. And let me say that I speak on my personal capacity. I'm not representing the views of the Competition Appeal Tribunal, and I don't have any conflicts to disclose. So when I use the term dark side, I did not mean it in the Star Wars kind of dark side, but dark side of the moon, in the sense that it's an unexplored side, right? So it has to be clear on what I mean by dark side. And I think, the emphasis I put then and I put now as well is on the workable aspect. I mean, as the Commission published this paper about the workable dynamic effects base, and they put workable first. And I think that was the main problem where, that basically led us to think more about presumptions. And I think it's very important when we think about designing a legal framework to make it applicable in every jurisdiction of the EU. And Article 102 is not only applied by the Commission or the Dutch or the German Competition Authority with dozens of economists and econometricians, it's also applied by the Greek Competition Authority, by other smaller countries' authorities, and by national courts that do not necessarily have access to economic expertise. So I think when you design a legal system, you need to have in mind as well institutional capability, and the system you put in place should be, applicable by everyone that is supposed to apply it. And I think that is why I guess we are emphasizing this idea of workable, because I have to say, and I share here my personal view and my personal experience as a head of a competition authority, is extremely difficult and risky if you are a small national competition authority to bring 1 or 2 cases. And usually the best thing is basically not to bring any, right? If you want to win at the courts. And I don't think that is a good idea to win at the courts, like the only element that we need to take into account for a successful competition authority. So presumptions are important, and in a way, they are part of this categorical thinking that we have, and the economists also have categorical thinking. We have different theories of harm, we have different types of conduct, which are analyzed according to different tests, so I think it's not necessarily something problematic. And let's not forget that the concept of naked restrictions is not something new. It was actually, it wasn't mentioned, but we have in paragraph 22 on the enforcement priority guidance, which was a more economic approach, a realization that, well, there are some practices for which we can assume that these are producing negative effects to competition. So what I would like to do is, and I don't know how much time, I'll probably focus a bit more on that aspect, is 4 issues that I would like to develop, 4 type of questions. So the first thing, what is the source of naked restriction? What makes it a naked, a restriction naked, all right? And some people say, well, the term is a little bit problematic. It's not a European term, it's actually, US term. Everything like hardcore naked comes from the US usually, and it comes from the BMI case in the US, or the US Supreme Court, which is the Section 1 of the Sherman Act case. But actually, it developed a little bit this idea that, well, these are restrictions that there's no economic interest for the undertaking except that of restricting competition. So there's no economic sense than exclusion type of analysis. Now, is this, and we have these 3 examples in the guidelines as well, the draft guidelines as well, more or less following up the priority guidance, but is this a little bit too narrow? And what I would say, there are different perceptions of what could be, a naked restriction. So first is this idea of no economic sense test, all right? Which is also put forward by the guidelines as the element that justifies the classification of restrictions as naked. I don't think necessarily that's a good test. It's actually, it's probably under-inclusive. To the extent that even actually with the case law, and I refer here to the Latvian railways case, which is, I think, Lithuanian railways case, which I think is an example of a case where you had this type of exclusion. So there was a destruction of an old track by a company, the dominant company, to avoid basically having its competitor having access to the route. Here, there were many different options for the company. It was possible to repair this specific track in 5 years. It was supposed to repair it immediately, and it might make absolute sense to repair it in 5 years. The court did not really analyze the different options from an economic perspective. Does it make sense for the firm? It only actually focused on the way this was done. This was done rapidly, without proper consultation, somehow, in haste. I think the court uses that term. So it's not really about this economic analysis that the test did in this case. It was more about focusing on the time, the way that the conduct happened. And I think, if you are focusing on this narrow criterion of the no economic sense test, that will not include what I think as the most important forms of exclusion, cheap exclusion, right? So let me just give you an example. I mean, a little bit, let's imagine that you have a dominant undertaking, that they use a surplus of dynamite that they have to, that they could probably otherwise have to destroy following strict safety regulations, to blow their rival's plant, and that probably could be a cheaper way to dispose of the surplus than to basically having to dispose it officially. Now, it's absurd to think that this type of practice should be analyzed to the extent that it's also, a possible anti-competitive exclusion, should be analyzed under an economic sense test. And we have cases like this, I mean, not necessarily blowing the competitor's plant, but think about Conwood in the US, where we're basically destroying the racks where, different products were basically offered by the competitors. So I don't think necessarily this is an economic analysis. It's more a moral type of ethical values that could possibly lead some type of conduct as being off the merits. Second type of issue is the constitutional moral principles. I mean, we have constitutional objective of the internal market. If there is a territorial restriction, let's think about Mondelez, where, apparently the Commission used a by-object restriction type of idea. Well, this is a type of conduct that eventually also could fall under this by nature anti-competitive type of practices. Think about eventually different forms of denigration of competitors or providing misleading presentations. We have actually in Hoffmann-La Roche, I mean, it was about a 101 case, but they were regarded as being sufficiently harmful to competition in language that looks very similar to the by-object restriction under Article 101. And, and of course, while in V4 and Teva, the Commission seems to have looked at some exclusionary effects or the capability of producing exclusionary effects. I think we can think about situations where the company knows that the information they provide about the competitors is misleading as an element. Think about conduct which is unlawful outside the context of competition law. Think about the AstraZeneca case, where the court used a concept of manifest restriction to competition, not naked restriction to competition. But I think this could eventually also be part of types of conduct that we can presume that they have some form of of the merits type of competition, or eventually situations like that we had in Meta, right? Not exploitative type of case, but imagine an exclusionary Meta case. So a restriction of data protection law that provides the specific dominant firm a competitive advantage and that enables it to exclude competitors. Is it something that we should consider as being competition on the merits to infringe the data protection rules or environmental regulations? So that's the first thing. Second thing is, are these basically the same as sort of irrebuttable presumptions? Or is this a problem with regards to rebutting them? I think no, because it is possible to rebut them, and there are many different ways. And first, we can think about these presumptions as proving a fact A leads to a normative conclusion B, right? So, but it is possible first to question about the fact A. So, for instance, the fact A did not happen. So the payment, for instance, to exclude the competitor did not happen. That is a possible way. Second possibility is that there could be no competition in this specific industry. And thirdly, you can eventually, and this is, I think, open to put forward objective justifications and efficiency gains to the extent, of course, that this is possible. I mean, in Super League, the court was somehow critical to the possibility of justifying through objective justifications the restriction of competition by object in that context, but they were quite open to the possibility of using efficiency gains as possible justifications. Now, is there any distinction between naked restriction and by-object restrictions? I mean, how can we somehow understand these different categories? I would say that, and I refer here to an interesting case, the Royal Antwerp case, which is actually a case that came out the same day as the Super League case, and it's a 101 case. But actually, interestingly, the court is distinguished between two forms of by-object restrictions. They say you have those that are particularly harmful to competition, such as horizontal cartels leading to price fixing, and they differentiate this category from other types of conduct, which without necessarily being equally harmful to competition, may also be considered to have an anti-competitive object. And they basically give the example of horizontal agreements other than cartels, such as those leading to competing undertakings being excluded from the market, or different types of information exchange. So there is this hierarchy in the category of by object. Eventually, one might venture the idea that naked restrictions are the kind of cartel-like type of conduct. Now, which makes me think about the question concerning, you pose that by-object category, broad by-object category, which might have a naked restriction part, to an effects analysis. And the question is, what do we mean by effects? And I think there's a lot of confusion about what we mean by effects. Usually, those that are advancing the more economic approach think effects meaning welfare effects, right? Or effects to the consumers. I don't think that's what the court basically does. So if you look a little bit to the cases, and what actually the court it means by effects. First, and I quote here Enel, Servizio Elettrico Nazionale, and TeliaSonera, specific conduct has the actual potential effect of making it more difficult for competitors to enter or remain on the market in question, or making more difficult or impossible the entry of those competitors into the market concerned. That's one type of effect. And then you have Super League, Paragraph 125, second possibility, hindering the maintenance of the degree of competition still existing in the market or the growth of that competition. This has nothing to do with welfare effects. It's basically about making it more difficult for competitors to have access to the market and making it the maintenance of the degree of competition in the market or growth of the competition being hindered. Now, this, I think, is a misrepresentation we have because we have started all these discussions about effects in the context of Article 101, where obviously, we're to a certain extent thinking about effects in the sense of welfare effects. I would claim that the capability to restrict, capability to produce exclusionary effects is basically about these two elements. Eventually, welfare effects could be taken into account when we address the issue if this is competition on the merits, right? And this is where eventually, the welfare effects might be taken into account. But this cannot possibly be only the welfare effects to the consumers. I mean, let's look to the Super League case, let's look at Google Shopping case, they refer to public interest, consumers, or undertakings, right? Let's think about labor restrictions to competition, like the Tondela case, which is actually a 101 case, but it could eventually also be a 102 case, theoretically. And you have, let's say, a company that through monopsony is able to reduce the wages of the workers with the idea that, well, we will be able to decrease the prices for the consumers. What actually the Advocate General Milieu tells us in Tondela, you need to focus on the labor side, all right? The markdowns is a restriction of competition by object because of the no poaching agreement.
May I interrupt you there? To ask if what Chiara, I think, was alluding to, and also Sir John Vickers before, isn't there a way to read the consumer welfare standard as broadly interpreted that can, respond to all those concerns that you have? And we need to do it in a minute or so.
I just gave you the example where there's inconsistency because you have a practice that eventually will lead to markdowns, so it will affect the welfare of workers, but at the same time it might benefit the welfare of consumers. They will pay lower prices. In this context, will you be basically looking to, an analysis of total welfare? Or are you basically going to do, as the Advocate General Milieu suggests in Tondela in 101, but again, the same case might come up in Article 102 as well. This is a restriction of competition by object. So what I'm saying is that we have been discussing a lot about it, and in the case, obviously, there is some reference to consumer welfare, and I think it's important. But let's not forget that, most of these cases were in product markets. And now we have a number of competition authorities around the world that bring cases in labor markets.
That is true, but also sometimes consumer welfare is more aligned with the labor market.
If aligned, there's no problem.
You also hurt consumers if you strategically withdraw your demand or
sure.
if you make
I'm thinking about the hard cases. Obviously,
as long as they're competitors.
Obviously, they are, thank God, most cases are not hard cases. So sometimes, the interests of the consumers and the workers coincide. But we can also think about other elements as well in this. So, and this is, I think, this is why the court is very careful. And this is the plenary court. It's Super League and Google Shopping. They basically say public interest, consumers, and undertakings. And I think it's quite interesting to put that in perspective. And final thing I wanted to say about the naked restrictions very quickly is how do you prove that? How much is enough, right? And this is an important question. How much of having this evidence of payments to exclude a competitor, how much of that will be sufficient to find that there's a restriction which is naked? And I think here Conwood, this US case is quite interesting because the same issue came there as well. And they basically said, well, we don't have necessarily to look to coverage. How many of the outlets of these supermarkets where, this dominant firm was basically destroying the racks through its employees, the racks of the competitor, how many of those, and if the competitor was somehow excluded from a sizable part or an appreciable part of the market? Absolutely not at all. What actually the court said, the US court said, well, we have to find out if this is not sporadic, so it's more than one or two occurrences, and it's not isolated. So, and in these type of cases are cases where the type of evidence you're going to have is basically witnesses, witness statements, is some internal documents. So and obviously this is practices which are a little bit like hotels. I mean, they're hidden practices. I mean, they're not putting in a commercial policy, right?
Ioannis, let's see if Chiara
I
increases your face on the consumer welfare. And if, Chiara, if you can help me here convincing or pushing Ioannis more towards the consumer welfare standard, but also speaking, what do you say?
It's a cartel of economists.
Yeah, we're doing a cartel. But it's an honest one because we're assuming it. And then also regarding the as efficient competitor test, how did you see the guidelines now clarify when it is useful, when it is not? How do you see that clarification? And how do you think that the guidelines really incorporate an as efficient competitor principle or not? What are your thoughts on that?
Okay, many, many things. No,
Sorry?
I just wanted to make a small remark on what you said about monopsony, because what the monopsony theory predicts is that, yes, the monopsonist is able to obtain lower wages, to pay lower wages through workers, but that is done restricting production and therefore increasing prices for downstream prices. So harm to workers and harm to consumers happen at the same time, so they are not inconsistent.
But it's broader than monopsony in some cases. I mean, that in other cases. So it's more about unequal bargaining, and this is not really exactly about
No, okay,
the class of
bargaining
monopsony,
can give different. And second, I think consumers' welfare or consumer standard could be interpreted even more broadly as it is proposed in the US, saying, okay, it's the trading partner. So when you sell to downstream, the trading partner is final consumers. When you purchase labor, consumers might be workers. So I don't think consumer standard is not flexible enough to incorporate also concerns in labor markets. So about the guidelines and the clarification on when to use the price cost test and when not to use, I think, again, that is another area where I think the guidelines are improving the situation. Because I think from the economic perspective now, again, it's clear that when some relatively simple pricing strategies are used, predation, margin squeeze, or rebates, conditional rebates, but that do not reference rivals, so relatively simple. These practices can lead to exclusion, but they need profit sacrifice. So the way I think the price cost test can be rationalized is we know that profit sacrifice can exist even when there are not losses, but a way to proxy profit sacrifice is, okay, if we observe that the dominant firm suffers losses, for sure there is profit sacrifice. And therefore, this rationalizes the use of the test, the price cost test, for these kind of practices. Of course, we know that profit sacrifice may exist even with the prices above cost, but it's difficult to establish. Let's say that for the sake of administrability and to avoid the risk of chilling legitimate competition, we can agree on the compromise of saying that prices above some measure of cost, it can be average total cost, long run average incremental cost, or whatever, but those prices should, I think it's fair enough to say that they should be a safe harbor for companies that are granted legal certainty. While for other practices that are much richer and therefore much more powerful, like rebates that reference rivals, in particular exclusivity rebates and exclusivity again, the literature is clear on the fact that not even profit sacrifice is necessary, and therefore the price cost test is not informative, and I think it's good news that the guidelines clarify that this, the price-cost test is not necessary at all when handling those practices. About the as efficient competitor principle, so now, let me make another remark. I think it's also nice the fact that the guidelines use price-cost test and avoid as efficient competitor test, because I think this terminology, as efficient competitor test, was a way that I don't agree with to interpret the as efficient competitor principle, because it's true, we should agree what the as efficient competitor principle means. To me, it was a warning, an important warning, that it's not the case that every time a competitor is excluded from the market, there is an abuse. And this was really, in my view, functional to the effect-based approach. Because in my view, the effect-based approach is justified by the fact precisely because it's not the case that every time a competitor is excluded from the market there is harm. We have to see whether there is harm. So we have to assess the effects that a given practice exerts on the market. And this is fully in line with economic thinking, because we know that excluding somebody may be beneficial. Yes. But at the same time, that doesn't mean that every time we observe that the competitor is less efficient than the dominant firm, then we can say, okay, no, there is no problem. Because that is not what economics says. And I think that the problem has been lies in this interpretation. The way as efficient competitor principle has been interpreted is, okay, we use the test all over the places for any type of practice, because we want to see whether the rival is less or more efficient than the dominant firm to establish where there is abuse. I think this is wrong. And this is not in line with solid economics, and has led to the fact that there has been litigations, never ending. We know very well how it went with the Intel case. So I think that it has been, the guidelines have clarified some issues, but the fact that they don't mention the efficient competitor principle, I think that may be problematic, because may suggest that the goal is to go back to a very formal approach and to forget about effects-based approach.
So, Chiara, if you would have to wrap up the recommendations for the Commission right now, in which I guess we are almost at the end of the procedure of writing the guidelines, what are your key recommendations to the Commission?
So what I would, an important suggestion to me is, what I don't like is that the theory of harm is never mentioned in the whole guidelines. While I think that analyzing a case of abuse should, well, the central thing should be the theory of harm, articulating properly, convincingly, a narrative which builds on the effects of the case, which explains why that practice, why means the capability of excluding, the incentives, and then the harm for consumers. And I think, and I also think, I'm really convinced that economics can really contribute to the theory of harm. This is where economics, I don't think, is useful, because it can propose, offer fancy quantitative tests that are an illusion that when there is a test, you just feed the machine with the data of the case and you have an answer, yes or no, this is good or bad. This is an illusion, and we have seen it very clearly. What I think economics can be very useful for is to understand the mechanism through which a given practice can exclude and can harm consumers, and through that help articulating a theory of harm that is solid, that is convincing. So the fact that this is not mentioned at all in the guidelines concern me a lot.
So, Max, you have Chiara's recommendations, you have the comments of Ioannis and Pinar. What do you have to say?
So first of all, I heard a lot of interesting things and a lot of things of which I absolutely see where you're coming from. So I will not comment on everything because there's simply no time. Just a couple of points on the relationship between consumer harm or consumer welfare and competition on the merits. It is indeed a topic on which we're reflecting. It's a very complex topic, but there are reflections ongoing on this point. Let's see where we land. And equally on the lack of reference to theory of harm, it was not at all intentional to undermine the use of theories of harm, because it is what we do in each and every case. So that's a point on which, of course, we're also reflecting on how to best address. On the AC test, I'll be very quick. We're not talking about an exercise which takes a couple of weeks to run. It's, according to our estimates, something that takes 2 to 3 years in an average case. So we have to make sure that we use it in the cases where it matters and where it is a reliable tool to demonstrate that there is an abuse. And of course, I fully see the points made by Chiara, which are indeed consistent with the approach in the draft. A couple of comments on Pinar's remarks. I think, Pinar, I'm not sure you read the same text that we have drafted, honestly, because we don't have presumptions everywhere in the text. The baseline scenario is that we need to show the capability of a conduct to exclude competitors, and then we have 2 conducts for which we say that there is a presumption, and 2 subcategories of conduct where we say that there is a presumption. Then we can discuss or disagree, or whether these are right or wrong, but it's not a scenario that is applicable to most of the conducts which have been, you said, I think, almost all practices which have been found to be abusive. If we look only at the 3 cases mentioned by Joao, Google AdTech, Microsoft Teams, and Facebook Marketplace, in none of this, under the guidelines framework, a presumption would apply. So I think it's important to make this clear. From a legal perspective, I beg to differ in terms of reading of the case law. If I only focus on the latest judgment, Qualcomm predation, I think, even mentions the word presumption. So it makes it clear that for predation, at least that's my reading, there is a presumption. And Intel 2, paragraph 144, says that only if the dominant firm comes with a defense, we need to look at the effects, meaning that the starting assumption, otherwise I don't see what the court will say only if, is that there is a presumption if, of course, the commission has proven the facts. It's not that we can just go to a firm and saying, oh, look, there is a presumptive illegal conduct, now you have to defend. No, we have to prove the facts, and we have to prove that there is exclusive dealing in the first place. And then the presumption applies, and we can discuss on what this implies. From an economic perspective, I'm not an economist, of course, but I think it's a little bit simplistic to distinguish between what you call modern economics oriented approach, which would be the use of the price cost test, versus old legacy concept. I think reality is different because, as Chiara was mentioning, modern economics has a knowledge that a price cost test does not work in every case, and some conducts may well be presumptively anti-competitive. So also from an economic point of view, I'm not sure that I agree with you. And third, just to clarify, the criteria of competition on the merits and effects in the guidelines in the draft guidelines are presented as cumulative. This is not the Unilever approach, not at all. This, in fact, is what the court told us in Super League. At least that's my interpretation of Super League, that the 2 criteria are indeed cumulative. So again, I'm not sure that this is in line with what we have written. And I think I will stop here. I don't know if I will have more time later.
Well, we're in a tough spot with time because we went beyond what we had planned. So we have a lot of questions still. So we need to make a choice. And since I'm moderator, I'm going to be draconian and decide alone. So let's do a last round. We are going to start with Pinar. Then we are going to hear Ioannis, and then we are going to end up with Max, and then a final round of word for each of you, but it needs to be very quick, and that's it. So let's follow this new plan, given that we went a bit over time with, and I had to be patient because Ioannis, you put up with me coughing through your intervention, which I couldn't help, and sorry for that. So Pinar, there have been important developments in the US. Our discussion has been quite Eurocentric until now, with monopolization cases, digital monopolization cases actually. Remedies have taken the spotlight there. This is an area which you have done a lot of work. So how do you read the developments in the US? What thoughts can you share with us on this regard?
Thank you. I'd actually like to take a moment to, if I may, respond to what Max has said. Well, I sort of have the draft here, and I can count exclusive supplier purchasing, rebates conditional upon exclusivity, predatory pricing, margin squeeze, certain forms of tying. And if you look at the case law, these are the types of conduct that have occupied most of the case law, except, as I said in my original remarks, for self-preferencing and so on, which are more novel types of practices where there are no presumptions. So I'm not really sure where the disagreement is there, because this is the types of practices that the guidelines count as practices subject to a presumption. And of course, there is also a presumption for all of these practices falling outside of competition on the merits, I think somewhere around paragraph 47 or something. So there are presumptions. These are, the guidelines say that the practices that are subject to a specific legal test fall outside of competition on the merits. I think that's paragraph 47. And 60B explains again that these practices are presumptively also going to lead to exclusionary effects. So I don't really understand where the disjoint comes from in terms of how many practices are actually subject to the presumption. And I did, of course, mention predation as being the example where there are genuine presumptions in the case law itself. Yeah, and I refer the audience for the rest of, I think, my responses to the paper we published, because with Chiara and Massimo, I think it's easier to explain some of those on paper. I don't know if I have enough time to go to remedies, Anna Sophia. I think we're already out of time.
Yeah.
So maybe that's for another time. Thank you.
Thank you very much. Now, Ioannis, we need to be very quick, but some key messages on what's left out, or if you want to go back to add the as efficient competitor principle, whatever you choose.
Okay, so let me just say, I don't think there is any as efficient competitor principle. It will be a principle if it is a necessary condition, so a sufficient but necessary condition to find an infringement. It is a sufficient condition because it's an analytical shortcut, but it's definitely not necessary. And I can refer to you to paragraph 264 of the Google shopping case, which is among other examples. So I think and then, obviously in the Super League case, we have the appearance of the not as yet as sufficient competitor element, or concept, which was basically in the discussion paper back in 2005, disappeared in the priority guidance, and then reappeared, I think, in the Super League case, and where actually the court doesn't even necessarily require that the exclusion is of an efficient competitor. Actually, they don't necessarily even ask for an efficient competitor. And I have to remind myself of this paper by one of my teachers of economics of competition law, Mario Rizzo, an Austrian economist who wrote a paper back in the 1980s, The Mirage of Efficiency, basically putting the idea that we don't have necessarily the knowledge always to assess, particularly in dynamic sectors, to assess where, if something is efficient or not. And we have to take a more dynamic perspective. Final thing, maybe my regret with the guidelines is the fact that they don't engage with ecosystem analysis. I think this is quite important, and there was a quite interesting progress with the communication of the notice, the market definition notice. I think it's very intriguing that this hasn't been discussed in the dominant position part of the guidelines, because I think it will save quite a lot of time for the Commission to have this more broader ecosystemic perspective, instead of spending like 15 years on one line of commerce and then starting a case for another line of commerce basically dealing with the same problem. It's basically better to deal directly with the problem itself and eventually adopt remedies that could relate to the whole ecosystem. And let's think about the 1956 consent decrees in the US of IBM and AT&T. They actually did not use the term ecosystem at the time, but they basically had to deal with a broader business model of both IBM and AT&T, and they enabled basically through these specific type of disclosures
The US
to exactly, and the fact that the
guideline.
unbundling that was done on a more general basis, and I think that led to the development of the computer industry and the development of innovation in this area.
An important point you mentioned is that tension in between, on the one hand, you having legal certainty, but also future-proofing. I think that's a very important point, because it's difficult to anticipate what form can abusive conduct take in very dynamic markets. Now, let's go back to Max, and then a final word from Chiara and Pinar, like a final word in, no? Yeah, okay, so we end up with Max.
So very quickly, just to dispel any sort of misunderstanding, there is no wording on presumptions in competition on the merits. Always says that if there is a specific legal test, then you don't need to look separately at the application of the competition on the merits principle, because that principle is already incorporated within the legal test. That's what we say of competition on the merits. And then for the others, I mean, tying... But, well, that's what you're saying, Pinar. We don't say that there is a presumption. This is a different interpretation. That's your interpretation. We don't say that there is a presumption. Whereas for effects, we do use the word in presumption, and again, in relation to two types of conduct and two subcategories. And on tying, none of the cases that were done in the past 20 years would have fallen within the subcategory of tying. So I think we're very clear on this. In terms of where we stand, I said we would have said a word on the next steps. I'm afraid I will disappoint, though, but I can certainly say that the process has been extremely helpful, because we heard some comments which were critical, we heard some comments that were supportive, but nonetheless, we have listened to everything, and now we're really working hard on making sure that the final text is useful for, first of all, stakeholders who have to apply the guidelines, but also for judges at national level and national competition authorities who will have also to look at that, I hope, and take inspiration for their cases. So we're working hard, we're keeping an eye on the courts, because of course there may be other judgments that could come, which could also be important from our perspective, but we're doing our very best to finalize the process as quickly as possible. I would like to thank everyone, because everyone who has participated in this consultation process, because again, all the input has been extremely, extremely helpful for us.
Well, I think that's one thing that we must all agree, is that it has been a very participated process, and the fact that the Commission can learn from the stakeholders, from what Ioannis, what Chiara, what Pinar have to say. May I close I don't know, because Max is addressing Pinar directly, so I need to push him for. So I think it's fair to have some time.
Just to clarify. So this is paragraph 47. Therefore, when a given conduct meets the conditions set out in a specific legal test, such conduct is deemed to be liable to be abusive because it falls outside competition on the merits. This may not use the word presumption, but this is exactly the language the court would use when it's trying to say there is a presumption because it's deemed to be liable. I don't see but what's the distinction then? You don't have to answer now. What's the distinction between being deemed liable to be abusive or falling outside competition on the merits, and that is presumed to fall outside competition on the merits?
But anyway.
No.
Okay.
Okay, no, I'm being challenged in my drink, but it's over.